Welcome to Free Thought Matters. I'm Annie Laurie Gaylor.
And I'm Dan Barker. Annie Laurie and I are co-presidents of the Freedom from Religion Foundation. We're a national association of freethinkers, that's atheists and agnostics, working to keep state and church separate. Please join us in our work so that secular constitution and reason will prevail.
And today we're delighted that our guest is Jim McCollum, who in the 1940s was the young schoolboy at the center of the landmark 1948 U.S. Supreme Court decision, McCollum versus Board of Education, declaring religious instruction in our public schools unconstitutional. We're going to be talking about his experiences and why it's so vital that the McCollum case precedent continues to be upheld. There have been books about the case, including One Woman's Fight by Vashti McCollum, who brought the lawsuit on behalf of her son, and The Lord Was Not on Trial by Dan McCollum, Jim's brother. The case is also the subject of a Peabody Award-winning documentary, The Lord Is Not on Trial Here Today.
Jim McCollum graduated in 1956 with a B.S. in geology from the University of Illinois Champaign. He earned his law degree from the University of Illinois in 1962. He served in the U.S. Army for 2 years. He worked in private practice as an attorney for 34 years. He's now earned 3 undergraduate degrees as a lifelong learner, and he's taught constitutional law and other courses at Southern Arkansas University for many years.
So, welcome to Free Thought Matters, Jim. We're really honored to have you here.
Well, thank you.
So you are as we said, the little boy who was at the center of this maelstrom, this very controversial case in the 1940s that made wonderful precedent to keep religion out of our public schools. Can you tell us a little bit about what it was like to be that kid, that school kid?
Well, needless to say, Champaign was part of the Bible Belt at the time. So my non-participation was not well received. Initially, however, they started working this particular so-called voluntary program down into the various grades, and it reached the 4th grade by the time I reached 4th grade. And they would send you home with a little card that your parents had to sign, and you brought that with a quarter back to the school, and that enrolled you in the class. My mother had some law school training before she met my father, and she certainly didn't think that was a proper type of curriculum for the public schools. So she essentially said no. The teacher brought a lot of pressure on me and on her. And as a matter of fact, the teachers got a little star on their door if they had a complete total attendance.
For the religion class.
Miss Hollingshead couldn't get her star.
So what were they doing? The preachers were coming in, outside ministers were coming into the school?
They had a couple of missionaries that had been expelled from China as a result of the end of the Second World War. And they were the ones that were the people who taught those classes.
And all religion, basically, in the Bible and Jesus?
Well, essentially it was fundamental Christianity.
So there was supposed to be one class for Catholics and one class for Protestants, is that right? But I'm not sure.
Supposedly they had a Catholic class, but I wasn't privy to it. And as a matter of fact, there weren't that many Catholics in Champaign.
So they were mostly just Protestant Sunday school classes.
Pan-Protestant class, essentially.
So we do have a little footage, Jim, of your mother talking about the case, and you talking about it, and actually your brother, Dan McCollum, from the late 1980s, and I thought it would be fun if we could see some history.
We have 3 sons. When the oldest one was in the 4th grade, he ran into this program of religious education in the school, public school, on school time. He came home with a note from the teacher that we were supposed to sign, give him permission to participate. We didn't approve of it. We thought that it was religious indoctrination, was the sort of thing that shouldn't be in public schools. And also we didn't want the religious training in any case. So we kept him out of the class until the peer pressure became so great, even the public school teacher called and asked that we permit him to participate. Finally, we let him take the course for a few weeks, and we saw that it was pure and simple religious indoctrination. It wasn't a course in general morality and good, wholesome, happy living. And so we took him out of the course. The pressure continued, and when it came to the point that we couldn't resist it, I took it to court.
Being the only child who didn't participate was a bit lonely and generated a great deal of hostility from the students and to some extent from the teachers. The hardest part was being so isolated from everyone else. It seemed that I was just about the only one in the school that had nothing to do with the course, and consequently had very little contact with anybody except certain teachers who were concerned about my well-being. But generally it was just like being isolated from the community. I suppose if there had been an even split in the class of those participating and those not participating, I would have been left in the classroom to study during times of the religious instruction. But since I was the only one, initially they put me in the teacher's office in the first school I was at. And in the second school, they put me in a desk in the hall, which was generally used for detention purposes. Eventually, when my mother complained, they placed me in the music room, which was also a place of detention, and caused certain remarks from the teachers as they came by. But even that was better than sitting in the hall.
It was a program which took time, and it was an inconvenience to the school day and routine. But a more serious problem was that at the very outset, a religious census was conducted to find out what numbers of students were, what the population was, religiously speaking, and it segregated from the very outset, just from this preliminary religious census, on through the actual conduct of the classes, segregated people by their religious beliefs. No longer was it any secret whether you were Jewish or Catholic or, in our case, atheists. So I think that in terms of actually invading a essential public area, as education is, and segregating people out by religious beliefs, that it definitely was a very, very un-American intrusion into the system.
So Jim, this lawsuit was taken. It was a very complicated lawsuit. Without getting into all the details, your family soon became pariahs in the community. It was constant pressure, media, everybody knew who you were. You were warned to be careful how you conducted yourself in public because everyone was watching. And your mother wrote a wonderful book, One Woman's Fight, a personal story about taking and winning this lawsuit. And I still remember, I read it as a 12-year-old myself. I remember her description of one Halloween night when there was a visit on your house. Do you remember that?
Well, yes. As a matter of fact, she answered the door. Usually my dad would answer the door for Halloween because he liked to chat with the kids. But this time my mother answered the door and was met with a barrage of rotten vegetables, which is kind of disconcerting, to say the least.
And I think your poor pagan pussycat disappeared one night.
We had a cat that was lynched, essentially.
By the loving Christians.
And you and your brothers had to get creative ways to get home from school, is I think the way that you've put it.
Mostly that was my problem. Dan, I don't think, experienced too much of that.
Your younger
and Era
brother
was just too young.
So there was a trial, which maybe wasn't such a good idea, but you were on the stand. You testified and did a wonderful job. Your mother testified.
I enjoyed the opportunity, quite frankly. But I was kind of nervous at the time, and the chair, the witness chair, was one of these swivel chairs. And I must have driven everybody nuts swinging around in that chair.
And I think
I was 11 years old at the time.
I think there was a dramatic moment where, I don't know if it was the prosecutor asked you if you had been told what to say on the stand, and what did you say?
Well, the school board attorney asked me, did your mother and attorney tell you what to say today? And I said, yes.
There was probably a gasp.
And he brightened up right away. And he said, what'd they tell you? And I said, they told me to tell the truth.
Tell the truth. And you did.
And I did.
There's some adorable photographs of you on the stand. But of course, then what happened? You didn't win that case at the
No, we
trial
lost
level.
before the circuit court. It was a 3-judge panel because it was a constitutional case. It was a mandamus action, and the writ of mandamus is a common law writ that you use to force a public official to perform their job properly. And that's essentially what, that's why the case is entitled People of the State of Illinois, ex rel. McCollum. Technically, legally, the state of Illinois was on our side.
And so, but you lost the case.
We lost the case before the circuit court, went to the Supreme Court of Illinois. Illinois' law was very clear, but the court chose to ignore it, and so we lost before the Illinois Supreme Court.
I remember your mother said, it looks like those judges had never even read the Constitution in their decision.
Yeah, she said that some of them seemed to snooze along the way, so I don't know.
So you lost again.
We lost again.
And somewhere in this, this court trial and trail up to the Supreme Court, you ended up leaving town because things were so hot.
Yes.
What happened?
Well, I was in junior high school, and it was almost completely impossible for me to really concentrate on studies at that point.
Because you were being picked on so much? Because
Well,
people knew who you were?
It was just a very hostile environment. I was essentially lower on the totem pole than the black kids were, and of course they were low on the totem pole to begin with.
This was the 1940s.
Yeah, and so it was.
So they trundled
it
you
was
off.
not a very good environment for me to be in school.
So your parents trundled you off to your grandparents in Rochester, New York, correct?
That's correct.
And your grandfather was a very well-known atheist. So he would have been a very sympathetic environment for you.
Well, yes. He became an atheist after he read the Bible cover to cover.
His name was Cromwell?
Yes.
Yeah.
Arthur Cromwell.
Arthur Cromwell.
Arthur G. Cromwell.
Very well known, became very well known in rationalist circles and so on.
Mm-hmm.
So you stayed there for a year and a half or so. Is
I
that
did.
right? And we're just about out of time, but we do want to not leave anybody in suspense. When this case went up to the Supreme Court, this brave little case, tell us what happened.
Well, of course, we won the case by an 8-1 decision. Justice Reed was the lone dissenter. The opinion was written by Hugo Black, who had authored the Everson case before that, and he had a very strong statement in the Everson case, which was quoted verbatim in the McCollum case. Scholars now generally will cite the Everson case rather than the McCollum case because of the statements, very clear statements that Hugo Black made. But the precedent was set by the McCollum case.
The precedent that the First Amendment rights apply to the states, that you cannot have religious instruction in public schools.
That's right. The Barron versus Baltimore, an early 1833 case, held that the Bill of Rights does not, or the Constitution does not apply to the states.
And so this was a landmark case. Your case was landmark because it applied those rights to the states.
The 14th Amendment did.
Yes. So we are just about out of time. When we come back, Jim, we're going to talk a little bit more about the legal import and also how the McCollum case is currently rather endangered and how important it is that children not be coerced or exposed to religion in the public schools, why we need to uphold that case.
And maybe you can tell us how you eventually got to meet Justice Hugo Black in person.
Hi, I'm Ron Reagan, an unabashed atheist, and I'm alarmed by the intrusions of religion into our secular government. That's why I'm asking you to support the Freedom from Religion Foundation, the nation's largest and most effective association of atheists and agnostics, working to keep state and church separate, just like our founding fathers intended. Please support the Freedom from Religion Foundation. Ron Reagan, lifelong atheist, not afraid of burning in hell.
And welcome back to Free Thought Matters. We're talking with Jim McCollum of the famous 1948 McCollum lawsuit outlawing religious instruction in the public schools.
And Jim, this was a really hard battle, and the odds were really against you and your family, and your mother never gave up. She was a petite young mother of 3 boys, and yet she had this steel-like devotion to the law, to your rights. Tell us a little bit more about Vashti.
Well, she had to work at being a mother. It didn't come easy for her, but she was an excellent mother. She knew how to guide her children along proper ways. She was never a person that looked for a fight, but you didn't want to pick one with her either.
Well, she did a pretty good job of mothering, I think. You boys turned out pretty good.
We did a good job of picking out our parents. There was no two ways about it.
Well, you were a schoolboy when this fight started, and here you're 83 years old, and you're still a schoolboy. You're still taking classes, getting degrees, or you're a true lifelong learner.
Well, it helps that Arkansas lets us old guys go to school for free.
So your mother hadn't actually completed her degree at the time of the lawsuit, but then she did go back to school. But also, she was very proud of the fact that she was named Vashti. And Vashti was the first, really only, exponent of women's rights that you find in the Bible. There's an Old Testament story about a woman named Vashti who refuses to display herself. Her husband, the king, wants her to display herself before men, and she refuses to.
In the book of Esther.
Yes, and so your mother was very conscious of that, and she was a very good current day Vashti, a feminist. And you've also said that your parents were very devoted to each other.
They were.
That you've rarely seen a couple who were that devoted through the years. But that your father, whose position was really almost threatened by, his position at the university was almost threatened by the lawsuit, and she lost her position. He never once criticized the lawsuit or said anything against it. He was fully supportive.
My father supported her emotionally to the very end. He had tenure, and they tried to fire him, but they couldn't because he had tenure. But his promotion to full professor was actually held up at least 10, maybe 15 years as a result of the case.
So there was a lot of economic reprisal, really, too.
Yes.
Well, it was a great day when that decision came down. Do you still remember it?
Oh, yes, I sure do. I got a telephone call. I was living with my grandparents in Rochester, New York at the time, and I got a telephone call that said we'd won the case.
And, of course, you later became an attorney, and it's so fitting that you have taught constitutional law. And in the film that we did in the 1980s, you very succinctly explain the importance of the McCollum case. So let's listen to that interview.
It was a very significant case. It is the first case decided by the United States Supreme Court that actually held the activity or action of a state municipality to be unconstitutional under the Due Process Clause of the 14th Amendment. Originally, the court in Barron versus Baltimore had held that the First Amendment of the Constitution did not apply to the states because the First Amendment starts out, Congress shall make no law respecting and so forth. So consequently, it was not until after the Civil War that when the Civil War amendments were passed, the 13th, 14th, and 15th, that the sleeper in the 14th Amendment became available. And for us, it became available in our case when the Supreme Court held that the Due Process Clause included the Establishment of Religion Clause. This had been discussed in the Everson case the year before, But the McCollum case was the first case where an action was actually held to be unconstitutional under that particular provision. All the cases that have followed thereafter in the church-state area have been based primarily on the McCollum case and the language of the Efferson case. This includes the Bible reading cases, the prayer cases, all of these cases that involve aid to public schools, or aid to parochial schools, and religious activities in the public schools.
So it really is a landmark case. It's been 70 years or more. All the other school prayer cases, cases against school prayer, commencement prayer, football prayer, have been based on the McCollum case.
Well, our attorneys are always quoting the McCollum case in the letters that we send out to schools all over the country.
There was one point that I didn't mention that was significant in that case, and that's that we were granted standing.
Yes.
And the standing issue had to be argued first before the constitutional case was.
And that's always the case. But of course you should have had standing when you had endured what you did and your mother was the parent.
They actually disputed it. The school board attorney actually disputed it.
Well, standing depends on injury, and your family was injured, so how could they argue?
Well, it had to do with, I think, the fact that we were my parents were taxpayers.
Yeah, now of course
they held it, the standing applied.
We've lost ground on that, but they would have had standing today as the parent of a child who was being persecuted. So you went on to become an attorney and to be admitted to the U.S. Supreme Court, and you went there in person, and you have quite a story to tell about what happened there.
Well, of course, as soon as I was eligible to be admitted to practice before the Supreme Court, I took the opportunity. My mother had some sort of a friend at the St. Louis Post-Dispatch that had connections with Hugo Black. And I had indicated that I really wanted to meet Hugo Black.
The justice.
Who
wrote the decision.
Yeah.
And consequently, a letter was sent to Justice Black that I was going to be there to be admitted to practice for the Supreme Court. So after the calendar call and all of the activities had taken place, a clerk came down, handed me a note, and said, "Go to that door, and you'll be admitted to talk to the chambers of Justice Black." So my then wife and I had a half-hour audience with this austere gentleman.
Wow.
Well, he was probably as delighted to meet you as you were delighted to meet him.
Well, he's an interesting fellow. As I was watching the Supreme Court, you had these austere-looking gentlemen sitting there, and then there's Hugo Black sitting at the end, rocking back and forth in his chair with a nice smile on his face. Very different from the other justices.
So you've taught constitutional law, and of course have had to talk about, teach about your own case, correct?
Yes.
And you say everybody already knows who you are in the class.
I never was in the closet.
So today we are looking at the Kavanaugh court and the religious right saying very overtly that they want to overturn the McCollum case and the precedent against religion in the public schools. Why would that be such a disaster, Jim?
Well, needless to say, it would add a lot of divisiveness in the schools. It would generate a lot of the prejudice that and bigotry that existed beforehand. It would not be a good idea, to say the least.
And you went through this terrible trauma as being the only atheist kid in the class. You know what it feels like to be targeted and be the minority that other children are all bullying and picking on because you're not the right religion. And this is what would happen all over the country if religious instruction were allowed in the schools and religious devotions.
Well, I was very fortunate. Things got kind of hairy there for a while. There's no question about that. But I see kids that run into the same problem again, like down in Louisiana, there's a parish just south of us where a young lady refused to stand for the Pledge of Allegiance and so forth. These problems are still with us.
Oh, yes.
And so you introduce something as divisive as religion in the schools. I think these kids are going to have a worse time even than I had, and many kids did. In fact, there was a Jewish boy that was in Champaign at the time I was, and when he was outed to one of his classmates' older brothers, he was beat up so badly that his glasses in a hardened case were broken. So it was worse being a Jew than an atheist at that time.
So the schools should be neutral. They shouldn't be for or against religion. You should go to school to learn how to learn, basically.
That's right.
Yeah.
And as your mother said, she didn't care if other people wanted religion for their children, but then they should teach it at home. And there's all kinds of non-school hours where parents can convey their thoughts on religion or take their children to church, but they shouldn't expect the public school to proselytize for them.
Less than a quarter of a child's waking and productive time is spent in school.
Well, you have done
plenty of time for parents to inculcate their children in whatever religious or philosophical belief that they prefer.
Well, thanks to the McCollum case, currently children are free from religious proselytizing in the schools, at least at the Supreme Court level, at least with court precedent. And it was absolutely wonderful gift to give this country, Jim. So thank you so much for being on Free Thought Matters.
Well, appreciate being invited.
And thank you for watching Free Thought Matters.
Because free thought matters.